morning, everyone. My name is Amy Manning. I am the co-chair of the Antitrust Practice Group at McGuire Woods, and I am also the programs officer for the ABA Antitrust section. I want to thank you first for being at this panel, but as programs officer, I also want to thank you for being at this conference. This is the second largest number of attendees we've ever had, and it's a wonderful opportunity for all of us to come together as professionals and talk about the information and things that matter most to us. At this panel, you're going to hear a view from the bench. We are going to, excuse me, we're going to cover everything from what makes an antitrust case unique, to discovery, to effectively utilizing experts, managing hearings and oral argument, trials, appeals, and a number of other really interesting pieces of advice that this wonderful panel has to share with you. We have a packed agenda, so I do not know if we will get to answer questions from the audience, but if you do have questions about these judges' views on antitrust, there is a QR code, and you can put in written questions and they will show up here, but no promises about whether we will have time for that. So to introduce my panel, we have Judge Gonzalez-Rogers, who is from the Northern District of California District Court. We have Chief Judge Proctor from the United States District Court for the Northern District of Alabama. We have Chief Judge Boasberg from the United States District Court for the District of Columbia. We have Judge Coate from the United States District Court for the Southern District of New York. And we have Judge Ginsburg from the U.S. Court of Appeals for the D.C. Circuit. A view from the bench. So let's start right in and have a conversation about what makes antitrust cases so unique. And Judge Gonzalez-Rogers, we'd like to start with you.
Yeah, good morning, everyone. Welcome to the ABA Antitrust Conference. I want to thank the leadership as I finish off my last year as being judicial rep to the section. It's been a fun time. So what makes it different? I would say there are three big things that make it different. One, discovery. Discovery in antitrust cases is some of the most complex that we as judges see. We're going to get into that in more detail. Two, experts. You cannot try an antitrust case without experts. And if you show up in my courtroom on day one and you don't have one, makes me skeptical about what you're doing, because experts are core to antitrust law. And I would say three, trials are different. They may be more like class action trials, but many class action trials don't get tried. At least that's what I've told. I've tried 4. They're different. I think they offer an opportunity to be creative, and I would implore you to think about that. Many of the judges who you will be in front of do not have antitrust experience, so creativity is another way that they can be different. It's not just the same old case. And I would say, finally, it's a specialty bar. You all know each other, and that has both challenges and advantages. So that is kind of the overview. I think we're going to get into each of those more deeply, but that's my overview for you, Amy.
Thank you. Judge Ginsburg, when we were getting ready for the panel, you talked about the open textured nature of the antitrust statutes. So tell us your thoughts about that.
Well, yes, the Supreme Court put it rather succinctly when they said about 50 years ago that the antitrust statutes are common law statutes, a phrase that has never been applied, as far as I know, to anything else before or since. A common law statute in the sense that the statute embodies the concept of a restraint of trade, which was a common law concept that had acquired a bit of learning over the course of the 19th century, before incorporation in 1890 in the statute. And the court's point was that doesn't mean that the Congress truncated the common law as it was in 1890, but rather incorporated the evolutionary aspects of the common law. That has, I think, permitted and blessed and invited the evolutionary incorporation of economics into the statutes. So now, of course, economics evolves as well. Industrial organization economics over the last 60 years has made significant advances, the result of which is that a lot of doctrines in antitrust law have been discarded. You can think of the 4 cases, piece by piece, disassembling all of the restraints on, all of the per se condemnations on vertical restraints. 4 cases over 40 years. Oddly enough, all of them anticipated by Justice White in the first of those 4 cases. But that really puts us in a very different position than we are ordinarily with almost every other statute, and indeed almost all the common law, insofar as we expressly incorporate economics.
Thank you. Others on the panel, thoughts about what makes antitrust cases different?
Well, I'll speak briefly to a slightly different question. We talked about how they are different compared to other cases. I'm going to speak about how they may be different for me. If you remember back in kindergarten, there was a project you got, and you would have to circle what did not belong in that picture. And you're looking along the panel here, and you're saying, okay, Northern District of California, Southern District of New York, District of Columbia, Northern District of Alabama. We're not exactly, the 11th Circuit and the Northern District are not exactly the fertile ground in which antitrust litigation grows. So what happens when someone like me, who doesn't have a lot of antitrust experience, nor economic education, I was a BA in individual directions at Carson Newman, where I played linebacker. So I walk in, let me just give a real-world example. In 2013, I walk into a courtroom with the top antitrust lawyers, or some of them in the country. Some of you are here, were in that courtroom that day for the Blue Cross Blue Shield MDL. And I realize that I am presiding over a case where you have devoted your entire career to this very narrow area, and I'm a generalist, and I've got to catch up. And that's truly a challenge, but it also means you've got to recognize that when you walk in a courtroom like that and be in a position to make things user-friendly for someone like me. So that's something I want you to be thinking about. I'm sure you already have to some degree, but be thinking about during the time we're going to spend together this morning.
All right, so let's talk about discovery. Judge Gonzalez-Rogers said that it is very complex, it is broad, it is deep, it is very expensive. I often say that I think antitrust exists right at the exact border of law and business, and so therefore if you have an antitrust problem, a lot of your business documents are relevant. So how do you appropriately manage discovery? And Judge Coate, why don't we start with you?
Thank you. I want to just say how pleased I am to be here today and participate in this conference. So I think there are many ways to, as a judge, efficiently manage discovery in a complex case, as antitrust cases normally are. And I think antitrust lawyers who are excellent in litigating antitrust cases have expertise in litigation, not just in antitrust. If you're a plaintiff's lawyer, you are someone who probably thinks about what you want to say in your summation before you write your complaint. You have a view of the long game, understanding what evidence you need to develop and what ways you're going to follow to develop that evidence. and you're thinking about what the defenses are that you expect to meet. And of course, as a defendant, you are thinking about those defenses and how to undermine the plaintiff's case right from the beginning. So I say this because discovery should be focused. If there are going to be disputes, they should be identified early on. You should be communicating to the court if you have disputes you can't resolve between yourselves or among yourselves, why the particular piece of evidence you want is important, or why the other side really hasn't made a case for this expensive piece of discovery. If I was, from the point of view of a judge, if I were going to talk about some of the things that good management of discovery has in common, I would say that you help the parties identify, maybe even require them to identify early any principal disputes they're going to have. You impose upon them the burden to confer with each other to try to resolve disputes before they bring them to your attention. You require them to crisply state their disputes, and probably as part of that, I personally have a requirement that no discovery dispute is brought to my attention in any submission, a letter submission longer than 2 pages, because I don't want to encourage the parties in letter writing campaigns. I want speed of statement of the problem and speed in resolution of the problem. And whoever you are or however you're managing discovery disputes, whether it's the trial judge or a special master or a magistrate judge, what you want is a prompt resolution so that the discovery dispute does not slow down the litigation. I think personally, and I manage discovery in all litigation before me, but including the complex cases like antitrust, there is an advantage of having the trial judge handle it, but it's not the only good way, and many dockets don't permit that. But if the trial judge can manage the discovery disputes, I think it does have potential advantages of cutting down on the number of disputes and ensuring that the trial judge has control over the speed of resolution of those disputes. For me personally, handling the discovery dispute has the advantage that I learn early on where the parties are focused, what is most important to them, and how they are functioning together or not. And that has advantages for me as I manage the entire litigation.
Chief Judge Boasberg, what are your thoughts on discovery?
And thank you also. I'm very happy to be here where we're talking just about antitrust. I thought that Judge Coate made some excellent points with which I completely agree, so I'll amplify my views on some of this, which I think are very consistent with hers. That as we all know, that antitrust discovery periods are going to be longer. They're going to be more complex. So what is the most critical facet for me? And that's progress and momentum. Getting bogged down in discovery does no one any good. It certainly doesn't do the judge good, doesn't do the parties any good. So the question is, how do we keep pushing the case along? How do we continue to have momentum? And so, and I think in many of the cases, the parties just want answers. They may not necessarily agree with what the discovery ruling is, but they just want rulings so they can keep going. So the longer you hold on to things and wring your hands, the less satisfied they're going to be. Even if you're going to rule against them, they just want a ruling. So I also don't refer discovery disputes to magistrate judges for the reasons Judge Coate says. I handle them myself. And I guess if there were a massive electronic discovery, but I'm not even sure then. I've never in my career referred any discovery matter to a magistrate judge. I've always handled them. So I also, like Judge Coate, don't permit lawyers to file motions to compel or motions for protective order. So without talking to me first. So what I typically do is I will require joint status reports from the parties every, say, 60 days during discovery. And those joint status reports will lay out all of the how far discovery has been achieved, what's been accomplished so far, and they will identify specific areas of dispute with each party's position, again, in one document. And then I will either have a hearing, a brief hearing, if I want to hear a little bit more about a particular dispute, or I will just rule. And I also will not write lengthy opinions. And in our court, we write a lot on a lot of motions, but I keep my opinions on discovery disputes very short because, again, it enables me to get the opinion out more quickly, and that's what the parties want, is the answer. So if I really feel like I need more briefing, again, as Judge Coates said, I will have briefs with very strict page limits, like 3 pages, 5 pages, and then rule. And they may just be orders with the bottom line, maybe a paragraph of reasoning on each, but the key is to get the answers to the parties. Now, again, this requires cooperation and conferring between or among the parties, and that's a good thing. And if you will quickly sense in these status reports or in hearings if one party is being particularly difficult because they're the one always taking an unreasonable position. So parties, I think, will make efforts to act more reasonably if you're going to hold them to account and if they have to continue to give their position in joint statements where they're just going to look silly if their position isn't reasonable. So again, a tight rein on discovery, continued status reports, continued rulings, and whatever you can do to preserve momentum.
Thank you. Chief Judge Boasberg or Judge Gonzalez, Rogers, any thoughts on managing discovery?
Well, we do it differently in the Northern District of California. I think most of us refer to magistrate judges, but I agree with my colleagues. If my docket allowed it, and I early on, just to get to know the bar, I did keep discovery. I think it can be faster. And our magistrate judges deal with discovery, I think, in the same way that my colleagues here on the panel deal with it. Short letter briefs, meet and confer. So there are 2 other things, though, that I'd like to mention that haven't been discussed. And that is oversealing of documents and claims of attorney-client privilege. I think the bar uses both of those issues to an extreme. Especially if you're in the Ninth Circuit, putting someone who's a lawyer's name on a document does not create a privilege. And the notion that it would is, at least in the Ninth Circuit, creates all sorts of problems with respect to discovery. So if you don't know what the circuit law is, figure it out where your clients are, and just know that we aren't going to tolerate you hiding documents under a guise of attorney-client privilege when there is none. Second, oversealing. You all want to seal everything. And I have to tell you, from our perspective, when we have to go through those sealing requests and make individual determinations, it is incredibly taxing on chambers. So I now have a standing order that's approximately, I think, 2 pages long in terms of what you have to deal with your sealing requests, because I'm not going to do it anymore. You're going to do the work for us. So again, when you are trying to seal things, it really is a question about what specific statement in your client's documents relates to business or proprietary information. It is not the whole thing, or frequently not the whole thing. So in these big cases, thinking about issues of sealing before you get to trial is really important. And talking to the judge in advance, having protocols to deal with this will help. But we don't have, just remember, we don't have big staffs. Most of us have 2 or 3 law clerks, and we have hundreds of cases. So help us out and be narrow in your requests and understand that we are a public institution. And that means transparency is important for the public and for our resolution of these cases. We are not going to seal everything just because you don't want it out there.
Chief Judge Proctor, anything for you?
I totally agree with Judge Gonzalez-Rogers about sealing and privilege issues. Those tend to be those among the things that lead to us losing momentum, as Chief Judge Boasberg was addressing. I think that I had a case in which there were I required a privilege log, and there were 1 million entries on the log. Think about that for a second. And I would tell you that I sit on the advisory committee on civil rules. We just had our meeting in Atlanta yesterday. I got to spend a lot of time with Delta Airlines last night getting here from Atlanta. And one of the things we're taking up is, should we address the rules as it relates to sealing of documents? I think it's pretty it's a pretty widespread view among the judiciary that we have to address that, because that's been an abuse that we need some tools to deal with. Question might be whether we need a national standard or let local courts deal with that, but it's a problem that has to be addressed. The other thing I would say is, just backing up, I also, when I sat on the Civil Rules Committee, I chaired the MDL Rules Subcommittee, and we have a draft Rule 16.1 that I think is pending at the Supreme Court now and is due to go to Congress. It deals with pretrial litigation and multi-district litigation. And I think a lot of the lessons we learned for complex and multi-district litigation there apply well to antitrust litigation. And that is having a good plan at the start, having a lot of meet and confers early, a lot of conferences with the lawyers to make sure we're off to a good start. If you're not off to a good start, chances are you're not going to finish well. And discovery is a key component of that. And so that's one of the things. If you're stuck on a plan for your antitrust case, the notes to 16.1 say that it can be used for other non-MDL litigation that's complex, and it's got a series of things that judges can ask the parties to report on for an initial management conference, and a lot of things the parties can devote attention to in their version of the kind of a Rule 26 report for MDLs, but the same thing applies to a Rule 26 report for non-MDL litigation like antitrust litigation.
Great, thank you. Let's now turn to experts, and Judge Gonzalez-Rogers accurately said sometimes the experts are the most important part of an antitrust case, and they have to explain extremely complicated things like regression analyses to a number of different constituencies. So Chief Judge Proctor, why don't you start us off on a discussion of how to utilize experts?
So there's two types of smart people. And believe me, I've learned that economic experts in antitrust litigation are smart people. The first type is, let's take a very straightforward issue and make it sound very complex so that we impress everyone with how smart we are. The more useful smart person is someone who takes a very complex issue, breaks it down to its ordinary components to assist and serve others in understanding the area. So that's the first question you need to ask, is what type of economic expert am I hiring? Which category of smart people does this person fit into? I asked my law clerk, my career law clerk, so give me some tips on what you would tell lawyers about how to deal with expert witnesses, and it's what you would expect. Let me ask you this. How many of you have had a case, let's show of hands, where it was predominantly the only case you worked on for a season of your career? All right? I bet if I asked the judges up here if they've had one antitrust case that they only worked on for a season of their career, no hands would go up. And that ought to tell you something, is you have to understand that we have a docket. I mean, we're gonna leave your hearing on your expert questions and go take a guilty plea, or go handle a summary judgment in an employment case, or a diversity case, or some other function of judicial business. And I think you've got to realize how important it is for you to top-line things for us, to bottom-line things for us, to break it down, and to make it explanatory. I was going to play a clip, and we decided not to play it, but it's the surplus episode on The Office, where Oscar is trying to explain to Michael about the surplus they have in the budget, and Michael doesn't quite understand what a surplus is. And he tells Oscar to explain it to him like he's 8 years old. And Oscar does that. Michael still doesn't get it, so he says, explain it to me like I'm 5 years old. Oscar goes into a hypothetical about a lemonade stand and how much money your parents give you to run the lemonade stand. The point is, I think that's a good exercise to remind yourselves that you're going to deal with folks who, like John Tiger, who has an economics background, I think an economics major, but you're also going to be dealing with judges who don't have that. And so how do you approach expert testimony and presentations with that in mind?
Are there examples that any of you can share without identification of situations where you've seen experts do really well or do really poorly?
Well, again, since we don't have to identify anyone, I feel absolutely free to speak. I would say in choosing an expert, it's important to think about not only their credentials and knowledge of the field, but also how articulate they will be if in giving testimony to a judge or to a jury, depending whether it's going to be a jury trial or a bench trial. But probably most important in the choice is, will they do the work? Will they study the documents? Will they crunch the numbers? Or if they have a team behind them, will they understand in detail how those numbers were crunched? Will they, in a situation in which they're asking for their expertise to go beyond what is normally accepted in the field, will they have such an intimate knowledge of the evidentiary record that pertains to their opinion that they can defend that on cross-examination effectively or explain it effectively in their written report? So my example is someone who was a Nobel laureate and very impressive and very articulate, but someone who had not put in the hours to actually be well-versed in the issues in the case about what they were testifying about.
And I just echo what Judge Proctor said, which is, particularly in a bench trial, you really have to do your research on your judge. In other words, if you're trying a case in front of a judge like Judge Ginsburg, you could have, if you tried cases, of course, that you could have experts talking at a very high level and may be someone who isn't brilliant at explaining, but who's very sophisticated in their background and knowledge. But you have to also look, they're judges. It's not just the judges of other cases on their docket, but there are lots of judges who may have come from a purely criminal background. They've never handled an antitrust case in their lives, and here's the first one. So you better have that lemonade stand expert ready, because otherwise you're just going to lose the judge. So it's not just look not just at the person's background, but you can find out how many antitrust cases have they had. And to me, this is sort of 101 before you're getting ready for that case, is you really need to know the judge.
And if I can pivot Daubert motions are not a way to educate the judge. I can't tell you how often I've heard that. Well, Judge, we're just trying to educate you. Look, there are better ways to do it. Again, Daubert motions are overused. And many of us, I think there are parallels from antitrust law also to patent law, so many of us also do patent law. I was at a conference with judges who do a lot of patent law, and we were talking about the overuse of Daubert motions. So just the headline. Just because you don't like the opinion does not mean you have a good Daubert motion, okay? That's not the standard. The question is, are they qualified to render the opinion that they are giving? And that's what we're looking at. There are judges now who say, file as many Dauberts as you want, but order them in the strongest to the weakest. Once I deny it, they're all denied. I now limit, in any case, you get 3. That's all you have. That's all you get. And again, you know, maybe there's one good motion where, back to Judge Coates' opinion, you have a Nobel laureate, but that Nobel laureate's not actually opining on a topic for which they're qualified to talk about, or the evidence, you know, is their opinions are totally disconnected from anything in the record. So back to creativity. If you want to educate the judge, think about tutorials. Tutorials are a good way to educate a judge on the law. Everybody gets a similar amount of time. Perhaps you want to try out your expert. Have the expert do some presentations. That way we're learning. We can ask questions that can be off the record. We do it a lot, again, in patent cases. We have technology tutorials. But we're not dealing with a motion that then has to be resolved and argued, and of course you can't agree on anything, and you're trying to strike their expert, so why would they ever agree in any event? So be creative in trying to educate the judge without creating more work.
Let me tell you about an actual conversation I got to witness once between 2 lawyers, and I was just the fly on the wall listening to them talk. One lawyer had put an economic expert up in an antitrust case, and it fell flat in front of the jury. And the lawyer was trying to figure out why, because this lawyer thought the witness was great. So the other lawyer said, tell me about the opinion and the way the expert delivered it. He said, well, I thought he got very practical. He told about when he was in college working summers at his dad's country club in the pro shop, how some of the retail transactions that he was involved in were very similar to what the jury was having to struggle with in this case. And the other lawyer just put his hand up and said, stop. You really let your experts say that in front of a jury? I think one of the things we have to do is manage not just the hyper-technical legal issues, the economics, but you have to understand you're also trying this case, if it's a jury trial, to a jury of folks that we just got out of the line at Walmart to decide how the case ought to come out on a factual basis. And I think that's another thing to back up and just think about, all right, big picture. One of my mentors was a lawyer in Huntsville, Alabama, named Rod Stakely. Rod had a practice. He would have a notebook in every case, and every time something happened in that case, interrogatories, production of documents, depositions, motion hearings, whatever it was, interviews with clients, he would get that notebook out and he would refine his theory of the case and refine his outline for how that case was going to be presented. It was a great picture of how you're managing the details toward a result that is big picture. And I think that's something that gets lost on us sometimes. We don't think, yeah, an expert doesn't need to get on the stand and talk about working in a pro shop with folks who have never been in a pro shop. So, pro tip there.
Judge Gonzalez-Rogers, just a follow-up on Daubert's. What is a meritorious Daubert motion? What is one that you would read, not specifically, but that you would say, yeah, this makes sense to bring this motion?
Well, I do think, I do think that there are issues, I guess in antitrust cases, it's hard to find one because the expert from MIT is just as qualified as the expert from Stanford, and that's typically what you bring. Again, I had a narrow one that I've granted in an antitrust case where I did have a Nobel Prize winner who tried to give an opinion on gaming. I'm not sure he'd ever played a game, but I find, to the extent that they're useful, I just find them in the smaller cases where you have people opining on things for which they're not qualified, or they haven't, people aren't spending the money on experts. We do have a gatekeeping function, but you all spend so much money on these cases. The notion that you would hire someone who isn't qualified to give the opinions that you want them to give, I just typically don't see it.
Great perspective. Thank you. Chief Judge Proctor, let's talk about hot tubbing. You have used hot tubbing before?
I have. So back to the Blue Cross Blue Shield case. I've used it in some other things, and hot tubbing works not just with economic theory or antitrust cases, but the idea that it was actually Eldon Fallon in the Eastern District of Louisiana who would have Science Day in some of his products liability cases. So when I inherited the Blue Cross Blue Shield case, I decided we're going to have an economics day. And we've actually had 3 of them during the course of the litigation. They've been devoted to different things. But one, I wanted to understand the markets. Another, I wanted to understand the business structure of the blues. We have 2 tracks in our antitrust litigation. One is subscriber, policyholders. The other is healthcare providers. So there's all sorts of things that you need to dig in to understand those things. So we've had these economics days. One of the orders I came across, and I wish I'd seen this order before I engaged in my economics days, is from Judge Chesney in the Northern District of California, your colleague. And it's in the hard disk drive suspension assemblies antitrust litigation. And she laid it out this way. The witnesses are going to meet and confer. The witnesses. They're going to prepare a joint statement that lists the top 6 issues of disagreement in the case in a descending order of importance. They're then going to counsel can facilitate the logistics of the report, but counsel may not participate in determining the contents of the joint statement. And then the joint statement is filed in with the court. And there's different ways to hot tub. You can have it free for all. You can divide up the time like you would at a hearing or a trial. But the key is you're trying to, what I say is it's a tutorial. It can't be used by any party in the litigation. There's a transcript being done, but it's only for me. It's for my educational purposes. No one's allowed to have access to that transcript. You can't cite anything that occurs in the tutorial. It is purely educational for the court. Now, someone who's got a lot of economic background may not need as much tutorial. There may be some benefits to it still, but that's the way I've gone about using those as tutorials.
Thank you. Any other comments before we move to hearings and oral argument?
Can I just say on the hot tubbing, again, thinking creatively, you could, in our district, you could also get Judge Donato. Judge Donato frequently has hot tubbing, but like Judge Tiger, has significant background in antitrust. So his hot tubbing works where the lawyers have zero input. And I know it makes all the lawyers very nervous. But it's basically he and the experts. And the reason he does it is so that he can zero in on what he what he thinks are the core issues and tries to understand it better. Again, an analogy back to patent law. While I haven't had one, the way I would do it and the way I do it in patent law is to have the experts up there and simultaneously, the issue is raised, as Judge Tesney asked them to do, so you raise the issue. One side presents, and I will frequently stop them and say, okay, stop. Now, do you agree or not agree? And we go back and forth. It's kind of more like ping pong. I'm not a big fan of the hot tubbing name. Maybe I'll start calling mine the ping pong table or something. But there are different ways to do it. Again, try to be creative. Maybe in one of your case managements with a judge, if you know this judge, to Judge Boasberg's point, who doesn't have or hasn't had an antitrust case, suggest some of these interim measures to help the judge learn about your case from both sides.
By the way, I've used this in ESI as well. I've come in with different debates about how we're going to conduct ESI discovery. I'd say bring your subject matter experts in, and the look on the lawyer's face when I tell the subject matter experts to go into my jury room and come out with a proposal on how we resolve this dispute. Air sickness bags are usually needed. Lawyers are losing control, but that's part of the process. Is we're trying to figure out ESI, economics, whatever. What do the experts have to say, and how does that inform the court?
All right, so let's turn. Oh, Judge Coate, I think you had either of you.
I was just going to echo what Judge Gonzalez-Rogers said about making sure that Daubert motions are motions that you think a judge can grant, not a motion that you're filing just to educate the judge when you don't think it can be granted. But I must say, in antitrust cases and other complex litigation, I do grant Daubert motions, and I find them very helpful because depending on what happens, there will be a quick settlement afterwards, and that'll be the end of the litigation. Or it will really streamline the trial. As long as they're meritorious, I want them to be brought, and I look forward to dealing with them.
The expert, we see this in the Court of Appeals, of course, after all the shooting is over. And our role is to, as others have said, come down and shoot the wounded. When we see the expert report, it's already been filtered by the district court opinion, and that makes the task somewhat easier. But nonetheless, I want to go and see the full report, and ideally, the expert reports on each side will have a succinct summary that is reliable. Let's put it that way, and that also includes the points of difference with the other side. Now that then plays into the briefs in terms of why that was a mistake, or what have you, in the lower court or in the agency, if it was an administrative law judge. And a very important aspect of an expert report is a frank recognition of the limits of what the expert can show. We had a case in the last week in which this was a securities fraud case, and loss determination was the issue. And the central feature of the case was the regression analysis done by the government's expert. And without prompting from the district judge, the expert was very forthright about what inferences could and could not be drawn from the regression analysis that he had done. And that was really very useful and kind of refreshing, but very useful because it cleared away some underbrush and left a clean understanding for the district court and for the appeal. There's one other point I wanted to make about that. Yes, so thank you, Judge Boasberg, for the compliment, but in fact, this is the stuff of our court all the time, usually and not in antitrust cases, because our task at the D.C. Circuit is primarily to provide adult supervision for the administrative state. And so we get cases from all of the regulatory agencies. In a piece I did in the Review of Law and Economics last year called Reimagining Antitrust Institutions, I discovered and laid out that there are somewhere north of 20 agencies that have responsibility for competition analysis. Some are supposed to refer the matter to the Attorney General for an opinion. Others there are variations on that theme. Some fly solo. And so cases involving electricity rates and oil and gas regulation and so on bring these issues about experts before us, all economic experts, all the time. And the issues are not all that different. I mean, a lot of them overlap with the issues that show up in antitrust cases, obviously. Some are unique to antitrust cases. But even a matter like market definition was a disputed issue in a Federal Energy Regulatory Commission case last term, where everything turned on the market definition with regard to oil transportation, oil pipeline transportation. So it was a sort of mini antitrust case. And so the bottom line of that is that everyone on our court is intimately familiar with these types of issues. And although we get, on average, one antitrust case per year, one Sherman or Clayton Act case per year, about probably 15% of all of our cases have these economic issues in them. So bring it on, folks.
Thank you. Judge Ginsburg, let's stay with you and turn towards oral argument and hearings. And in antitrust cases, they're incredibly complex and voluminous records. How have you seen people simplify the incredible amount of information in a way that is effective?
Well, this is my hobby horse. To begin with, in your briefs on appeal, and maybe this should go for district court as well, you cannot do better than to add some graphical material. You never sat through a law school class that involved any complexity in which the blackboard was not in use, right? Relationships, corporate transformations, divisions or principals and agents. It's the stuff of presentation in the law, and yet hardly anybody does it in their briefs. It's actually remarkable. Now, a few years ago, I gave the lecture at the Antitrust Division. There's an annual lectureship there on this subject, and I had my law clerks do some research, and what we found was the number of and percentage of briefs filed in the D.C. Circuit that had any graphical content was minuscule. And the vast majority of those that had it were filed by the FTC or the Antitrust Division. They know it, and you should know it. Take as simple a case as the first Staples merger, right? There's just a 9-cell matrix showing 3 markets that have a monopoly and 3, 2, or 1 competitors, and 3 products, and the prices in the cells. And it just shows that the prices are higher on all 3 products, the fewer the participants in the market. Now, it requires some explication, and there was some objection to it in the responding brief. But as one of my colleagues said in a similar case, holding it up to counsel and said, the opposing counsel, what's wrong with this picture? The picture captures so much information, and it's a tool of advocacy. If you do it honestly, it can still be a tool of advocacy. So it's a real failing, I think, particularly, I'm not sure particularly, but certainly in my view on appeal, where we've got an enormous record and several issues And if it can be brought down, simplified, or grasped more readily, some people learn better visually, I know I do, then do it.
Great. Thank you very much. Chief Judge Boasberg, thoughts on effective oral argument hearings, and also when you decide something is worthy of an oral argument or a hearing.
So I think that different types of hearings, obviously, and in discovery hearings, again, I'm frequently having them to try to push some consensus and to narrow the areas of disagreement because, as Judge Gonzalez-Rogers said, I don't have time to go through hundreds of documents to decide which is privileged and which is confidential and what pieces of each should be out or in. And so, again, the hearings, I do that to see if I can narrow the areas of disagreement. So my advice to you, if you're in those hearings, is be the more reasonable player, because if you are, you're going to end up securing victories typically. The other thing I frequently do, and not just in antitrust cases, is if I am having an oral argument, I'll actually, in my order setting the oral argument, say what the parties should focus on. And I do that for two reasons. One, to save you time, because otherwise you may be spending a week or weekends prepping something that I really am not interested in. And second, to provide you with guidance so that you will be able to better help me when you show up. Because if I don't give you that, maybe you're going to tell me exactly what was in your brief. I know it's in your brief. I wanted more specifics, or I wanted more what the ramifications of ruling a certain way, or how to differentiate certain cases. And so I try to direct parties to specific topics that I'm interested in, which I find fruitful, and I think parties appreciate it.
Other comments on oral argument or hearings?
I have hearings all the time. Anything that's important, you'll probably get a hearing. Rarely, I'd love to, I aspire to do what Judge Boasberg does and get things out early. I will let people know early if you're not coming in for hearing. But again, for me, the ping pong approach works the best. So one side starts. Rarely, if ever, does anybody's planned speech continue. Usually interrupted within minutes, and we go back and forth, and then we go to the next issue, and we go back and forth. And that helps me understand and crystallize your arguments better. And then I skip over things that I don't think I particularly need argument on. But going back to what Judge Ginsburg said, I think graphics is really important and can be helpful. And I love charts, and I think charts are a great way to, put both perspectives in a summary way right next to each other. I actually do require all expert reports to have an executive summary up front. And if you don't, your expert report can get stricken. But again, I try to have rules that make things easier for me to digest more quickly so that I can get answers back to you more efficiently.
And I'm slightly different. I don't hold a lot of hearings on things that I don't think I need to have hearings for. Justice Thomas, for years, didn't ask questions at oral argument. And he was asked why. And he said, because if they can't explain it to me in the papers, how are they going to be able to explain it to me in 15 minutes or so at an argument? And I lean that way too. If I hold a hearing on something, it's because I have a question or I'm uncertain about an outcome. And also, if in big cases, one of the things that I think, as Chief Judge Boasberg said, moving the ball down the field, having a lot of monthly or periodic management conferences, a lot of those things can be addressed in those. And that gives a good opportunity for everybody to get together and keep momentum going. But generally, if I get that on the papers, I'm understanding that good lawyers, using graphics or whatever else you use, ought to be able to break these issues down for me, give me the law, and give me a reasonable explanation about how to apply the law to your problem. And I'm not going to set for oral argument just for funsies.
All right, let's turn to trials. And Judge Coate, I'm going to start with you to share with us any of your advice regarding trials or your observations.
So I have not had an antitrust jury trial. I've had several antitrust bench trials. So I think what I'm going to do is restrict my comments to bench trials and antitrust cases. I follow a practice that preceded me in the Southern District, and I expect around the country, and that is I take direct by affidavit. What that means is a witness's direct testimony is presented with a pretrial order in an affidavit form, and all the exhibits that the party will use in its case in chief. And then I spend the interim time before the trial itself drafting an opinion. So at the trial, the plaintiff will call their witnesses, they'll swear to the truth of their affidavits, and they'll be tendered for cross. Now, stepping back from this, what this means is, one, there is no summary judgment practice, because instead of taking a summary judgment motion where I'm searching to see if there is a disputed issue of fact, I just decide the issues of fact. Two, I don't have post-trial briefing. So what this does is shorten the time frame for the parties so you can get up to the Court of Appeals faster. The trials are also very short compared to what it would be if it was a jury trial. And I come prepared to the trial because I have this draft opinion. I know what I don't know, or at least I think I know what I don't know, and I can ask my questions. Counsel, I think, are enormously advantaged, as their clients are. They can really craft the direct testimony with their witnesses with care. They can prepare for the cross-examination. They have plenty of time to know how to organize their cross and what points they want to make. So cross-examination is extraordinarily efficient. I enjoy the summation argument. We've all been through this intense experience together, and I know the case well by that time and can have pointed questions and a pointed dialogue with counsel on any issues that are really at the crux of what's going to drive the decision. But I really, besides the advantages to counsel of control and efficiency, I think the time frame and the saving time, taking out the months that might be involved with briefing and decision on a summary judgment motion, and taking out the time that might be needed for post-trial briefing really means that this case gets tried on a faster basis with me being better informed. Thanks.
Thank you. Judge Gonzalez-Rogers, can you share your thoughts with us?
So I have tried a jury trial in an antitrust case and have done the bench version as well. I think a lot of the things you've heard today relate to jury trials as well, which is, and I'll go back to what Judge Proctor said, you have been living with this case for years, and you have jurors who are there, who are just normal people, who've come to do their duty in a courtroom, and it's complicated. But the skill is to take that complication and reduce it to something that they can understand and engage with. So remembering to focus on the forest is important, not just the trees. So at least, you know, when you all go to do trials, I'm sure many of you have done many jury trials, when we talk about having a theme, that theme really matters. And you really do need to figure out what your theme is and how it threads every witness in order to reach the jury. and to convince a jury. I think you have a little bit more flexibility if you're in front of a judge. We've been in trial before. You don't have to do all the grandizing. Do you remember when I took your deposition on July 4th, 1952? And didn't you promise and swear to tell the truth? It's like, okay, yeah, we get it. Just could you, like, what was the, how are you trying to impeach? I understand you need to do some of that grandstanding in front of a jury. But for them, it seems to me, it's really about the big picture. And not only that, if you're a plaintiff, you have class members who are your named class members who are telling your story. Don't forget that. They're telling your story. And they may just be, you know, the clerk at the local drugstore. So they're not necessarily, you know, they're not the actress or actor. So they do have to be compelling, even though it's really your expert that's the core of the case. As a plaintiff, you have to still describe that case and why it matters to the people, the public, to the jury through this individual. On the defense side, you need to be really careful about tacking that person. It's not so much about credibility, right? Because they're just the normal person. And the jury's actually going to connect with that witness in a way that's pretty intense, because that person is just like the jury. So be really careful about attacking them, because you're the lawyer, not the person, not the citizen, not the jury member.
I'm sorry.
No, go ahead.
I was going to ask, but I bet we have a shared experience on the jury and the non-jury trials, and that is the importance of controlling the technology in the courtroom to display things quickly and efficiently.
Yeah, go ahead.
So those who are not masters of technology in the courtroom need to become masters. Your paralegal or assistant, technology assistant, may be as important as any lawyer on your team. And you don't want to slow down the presentation for the jury or for the judge. But to follow Judge Ginsburg's point, the drama of a chart, a graph, a document, it can really bring the whole case together, presented to the judge or to the jury in the courtroom.
And I would also, you know, the other thing that you may want to think about is what does the appeal look like? You know, when you're a judge, we have to actually explain to you in our writing the factual reasoning for why we have the factual decisions that we're making. I kind of find, and maybe Judge Ginsburg will weigh in on this, I kind of believe that if a jury makes a factual finding, appellate judges are less likely to overturn them than if a judge makes a factual finding. I kind of feel like a 3-judge panel is like, well, you know, we're judges too, and you're not supposed to, but it feels sometimes like factual decisions are easily turned or overturned rather than a jury. We believe so much in the jury system that those factual findings, I think, just as a practical matter, are really given quite a bit of weight.
It's a great segue to talk about appeals. So, Judge Ginsburg, talk to us a little bit about appeals and the fact that you're often having to decide issues of antitrust law.
Well, first let me say that I haven't noticed a disparity of the sort Judge Gonzalez-Rogers just described, but that may be because we have so few jury trials in the district. Even if we have a criminal case with a jury, it's likely that the appeal is going to be limited to sentencing. So it's really quite rare. I mean, I remember when one of our judges came on the district court, this is about 10 or 12 years ago, went the first year and a half without a jury trial. It's just, you know, people plead and people settle, and so it just isn't that common. So I don't have enough of a base to answer the question of whether we're more reluctant. We're always reluctant. I mean, the clear error standard is pretty daunting. So you're well protected, I think, in that. Now, as to legal issues on appeal, there's a strong norm in the D.C. Circuit. I think it's probably true throughout the circuits, but I'm familiar with the D.C. Circuit. There's a strong norm against deciding anything that doesn't have to be decided. Finding narrow grounds for resolution of a case. It also facilitates a panel coming together and avoiding fragmentation over issues that could be put aside for another day. And occasionally there are reasons for departing from that. But generally, that's our guiding norm. Now, that said, there are antitrust cases that present sometimes several important legal issues that have to be resolved. And in some cases, we're writing on a fairly clean slate. To go back to the warhorse of the Microsoft opinion in 2001, there were the issues there that were resolved that were completely new were the burden-shifting framework for Section 2 cases, the inapplicability of per se condemnation of tying in technology cases because there wasn't an empirical foundation for saying this should be per se unlawful because it almost always is indefensible economically. There just weren't cases, so we couldn't say that. So those things had to be, well, they were decided. They were broad and still controlling now 25 years later with respect to actually to both of those. Merger cases where there are circuit splits. For instance, the Third and the Ninth have had a persistent split on bundling and tying, and the burden put on the plaintiff in a private civil matter. And the Supreme Court hasn't given us any guidance on Section 7 since 1974. So it's 50 years of circuit court law out there. Doing the best we can with what the court left us. And what they left us was Philadelphia National Bank in 1963 and a gloss on that in 1974. The case, the facts that arise, the industries that have come into existence then present issues that just cannot be resolved by reference to what the Supreme Court said 50 years ago. And so the circuit courts are put on their mettle to do the best they can. And that is, it's unusual, I think, in this, for antitrust to have a major area like mergers with 50 years of no guidance from the Supreme Court. And the problem is the repeal of the Antitrust Expediting Act. People cannot keep a merger on hold for 3 years to get a Supreme Court opinion. It used to be it went up, and in 18 months it was resolved by the 3-judge district court and by the Court of Appeals. Issues that are going to come our way are the legal test for antitrust injury in nascent acquisitions, nascent competitors, the scope of antitrust remedies, which is being laid out right now in the district court, right in the Google case, and it's undoubtedly going to present all novel issues in the context of potential divestitures. Proposals from the department that have been under submission are, I think there are 5 or 6 variations with a sort of list of preferences, but in any event, the district court's being asked to do things that are very case-specific and novel, and we're going to have to decide what to do with that. Now, aside from the norm of keeping decisions narrow, once we have something we have to deal with, I think the first question that comes to mind is, of course, the economic question. What seems to make the most sense? I mean, I've had cases, not necessarily antitrust cases, in which I've said to counsel, it seems that your proposed rule here does nothing other than increase transaction costs. I mean, it really doesn't have any other effect. And if that went unrebutted, then that's the end of that theory, because there's no way in which that would fly. So we had a case earlier this week, again, not an antitrust case. The question was, what bright line rule makes sense? So everybody knows that they needed a bright line rule. So which one makes the most sense? And, these are very practical questions because there isn't any legal guidance to answer a question like that. So it ends up being practical, and that's the way ultimately we have to resolve it. It's not ideological, but it's not textual. There is no text. Sherman Act isn't going to help us on that. So that's it. That's how we're flying at night.
Thank you. So I know we're at time, but I hope you'll stay for this very last question. One of the best things I think about the antitrust section is that we have incredibly engaged members, excuse me, at every stage of their career, from first-year associates all the way up to seasoned partners. And so I asked each of the judges to please give us a piece of career advice. So Judge Gonzalez-Rogers, can I start with you?
Okay, so here's my, we're about to have lunch. And what I tell young lawyers, it's really more for the younger lawyers, go today and have a piece of pie so you'll remember what I'm about to say. Forget the diet. Pie. Passion, integrity, and excellence. That's my acronym. We spend a lot of time working, so you should be passionate about what you do. Integrity matters. It really does. Your reputation matters. Being reasonable matters, as you've heard today. So that's integrity. And excellence, I think justice requires it. Justice requires that we do as great a job as we can. And so I find that that's a good motto to live by: passion, integrity, excellence.
Lovely. Chief Judge Proctor.
That pie is good for you. So you might notice that culture is seeping into every institution we have these days. Sometimes it comes in like a wave at the ocean. Sometimes it just seeps in like water in your basement. What I would tell you is be the thermostat, not the thermometer. There's a lot of thermometers in the room, and those reflect the temperature that you bring into the room. It may be you're not happy about a ruling. It may be that your client's not happy about being sued, or your client's not happy about how the legal process is working in a particular case. There's all sorts of things that affect the thermometer. Your job is to be the thermostat, set the temperature in the room, and be the leader in the room. There's 3 areas we use to make decisions: technical expertise, knowledge, moral compass, but the big one that we rely on more than the others even is wisdom. Being able to see around the corners, making decisions. Should I go to this firm? Should I marry this person? Should I take on this client? Should I exercise my discretion as a lawyer in order to do this or that? There's a lot of it is wisdom-based. Work on your wisdom. Work on figuring out a way to marry the use of wisdom to set the thermostat.
Thank you. Chief Judge Boasberg.
Take a job that is meaningful to you, that has a sense of purpose that you subscribe to, that has a mission that you can feel proud about every day, not just something that pays the bills.
Judge Cope.
Wow. Fabulous advice. I want to just speak to the young lawyers. Find a good mentor wherever you are and ask for an opportunity to stand up in court. You will find, I expect, most judges very open and receptive to having young lawyers handle arguments, handle witnesses in their courtrooms. If you know your stuff, you, in fact, may be the attorney who knows it best. Judges will appreciate the fact that the firm, the senior partner, the partner in charge has given you this opportunity, and if you've done your homework, you will find a receptive bench.
And Judge Ginsburg.
You may not realize that it's the water we swim in, but the antitrust the ecology here in the United States, true in the UK and a few other common law jurisdictions, is unlike that in the rest of the world. And it gives rise to, I think, a superior judiciary and antitrust judiciary, government agencies, and law practice, superior to what you can find anywhere else. And the reason is that we don't have these silos. We move back and forth from government to private practice. I advise my clerks, I have an antitrust clerk every year, I advise them to spend time in government. They may end up staying. Danny Haar's now head of the Appellate section, Department of Justice. They may go out after a few years. Taylor Owings is now out at Wilson. They may do this even not just at the beginning of a career, but later on as well, when they can come in at a policy level as a deputy or something like that. But it's what makes our whole system work better than it does in any other environment where everyone is siloed and no one's had the experience of being on the other side of the table. So.
Thank you, and please help me in thanking this wonderful panel.
Good to see you.
Good to see you.